Probation is not a strange term in employment contracts. It simply means that an employee is put on trial to prove his fitness for the job position for which he is employed in terms of his performance, conduct, and character. Basically, a probationary period is left to be agreed upon between the employer and the employee. There is no law governing the length of the probationary period. Hence, a probationary period as stated in the employment contract shall be regarded as a contract of an agreed period or duration of the trial of a term certain. The term probationer is not defined in the Employment Act 1955 or in the Industrial Relations Act 1967. There is no statutory definition of what is a probationer. However, case law does distinguish between a confirmed employee and a probationer. A probationer continues to be a probationer even at the expiration of the probationary period if, at the end of the period, his per-services had either not been terminated or are confirmed. The law provides that a probationer remains on probation until he receives notice that he has been terminated or confirmed. The importance of a confirmation letter should therefore not be underestimated. Generally, in order to terminate a probationer's employment based on poor performance, some tips. As long as the company makes known to the employee his shortcomings, inefficiencies, and instances of unsatisfactory and poor performance in a proper, coherent and cogent manner, thereby ensuring procedural fairness, the court will regard the company as having met the test above. A probationer enjoys the same rights as a confirmed employee. Therefore, a probationer's service must not be terminated without just cause or excuse. Since the law recognizes that an employee under probation has the same rights as a permanent employee, the probationer's services cannot be terminated or dismissed without just cause and excuse. The dismissal of the probationer may be open to a claim for reinstatement and back wages for up to 12 months. I still didn't get an official confirmation letter from the employer, however, I was allowed to go on annual leave. What is my status under the law? Generally, there is no automatic confirmation in Malaysia. The probationer is allowed to remain in employment, he is neither confirmed nor discharged from employment. However, the court may recognize that the probationer was confirmed as a result of the employer's conduct, such as when the probationer is treated as if he was a confirmed employee. Facts: the employee was employed as a clerk and in the contract of employment it was stated that his probation is for 3 months. The employer did not write an official letter of confirmation to the employee. In his contract of employment, it was stated that the employee would be entitled to annual leave if he was confirmed. Despite not being given an official confirmation letter, the employee was allowed to go on annual leave. It was held that due to the employer's conduct in granting annual leave to the employee, which was only for confirmed employees, the employee is regarded as being confirmed. In case of inefficiency and unsatisfactory work performance leading to dismissal, the court has to be satisfied. 1. As to the manner the worker has failed to perform. 2. Whether he was pre-warned or notified of his performances. 3. Whether in spite of the warnings he still failed to perform. Lastly, the company had acted in good faith and in a reasonable manner in its conduct towards the claimant. 1. Malaysian laws are very pro-employee. Section 20 applies also to probationers. 2. Employers should be very careful in employing. It would be ideal if a proper thorough background check is conducted on an employee in order to determine his or her suitability for the job. 3. Employer must have just cause or excuse for non-confirmation. Employers must have exercised the discretion in not confirming an employee on probation in a bona fide, good faith manner. If the reason is for poor performance, then there must be evidence to show, for example, letters written to the employee, monthly assessments, warning of poor performance, etc.